some of the reasons include amendments to the False Claims Act that were passed in 2009, the Fraud Enforcement Recovery Act, FARA. There was an amendment in the healthcare legislation that had an important change in the False Claims Act, lowering the public disclosure bar. You've had the Justice Department engage in very aggressive enforcement actions of the False Claims Act, particularly in the healthcare area. You've had an increase in investigative resources available to the government. You have very significant incentives available to relators and relators counsel. All of these factors taken together really create a number of directional arrows pointing in the direction of more activity, and that's being borne out. This 2010, there were approximately $3 billion of recoveries on behalf of the government, either through settlement or judgments, and I think that's an indication of what's to come. I think that companies try to and should try to have reporting channels that are credible, and by that I mean reporting channels where individuals understand that the company is committed to a culture of honesty and ethics, where the reporting channel provides for confidentiality, where the company says that it is going to not have reprisals or retribution against company employees that do bring complaints forward. There are a number of cases in an area called implied certification, which I think are particularly important. Under the False Claims Act, you have to have a false statement, material to a false claim, or a false claim. And where you've got some activity, some statement occurring outside of the invoicing process, the courts have, in some jurisdictions, developed a doctrine called implied certification to connect falsity with the claim. And so, best understood in a jurisdiction recognizing, or a circuit court recognizing false certification, where there is a statement where the company is not in compliance but bills, and from the government standpoint, compliance with some requirement is a prerequisite to entitlement to payment. Courts have treated that in some cases as an implied certification. This whole area of implied certification is rapidly developing. There are numerous Circuit Court of Appeals cases, and how those are articulated and what standards emerge and how they're resolved among the circuits, I think, is a major issue. Well, obviously avoidance is a wonderful strategy. I think assuming you're in a situation where you're named in a suit, or where it's likely that you will be named in a suit, I think doing a careful internal investigation, finding out whether you have a defensible position, is very important. I think for those in the government contracts arena in particular, where the company has developed credible evidence, disclosing that problem and matter to the government, getting out in front of litigation through disclosure in remedial actions is a very important strategy. I think if you're in a situation as a company where you're named, the complaint is now public, working that complaint, developing, pushing the defenses that are available, and trying to resolve the matter. Most False Claims Act cases in front of juries are very difficult, and so it's not to say that they're not winnable, but it's a difficult situation. So companies need early case evaluation where they have a filed False Claims Act action, and efforts to try to resolve those cases early are generally in the company's interest.